Good evening to everybody. Welcome to the today class and to the students of the Advanced Private International Law. And please read what I posted on the screen. Anyone can unmute and read what I posted on the screen. Yes, and let me read it. What is the aim of the private international law? The aim of the private international law. Private international law aims to allow the streamlined civil judicial cooperations across the national borders. It seeks to avoid the need for the multiple sets of the court proceeding relating to the same dispute. Yes, same dispute, particularly where there is a risk that these could result in the conflicting judgments. Professor Dr. Mohammed Saheb Hussain. So this is the aim of the private international law. And I voluntarily I could not deal the separate obligations, torts, and contracts, matrimonial. And once we conducted the first internal, later could see that and concentrate on the four aspects of it. Once we completed the four aspects of it, that means the total course is completed. So now in this class, let us see what are the rules of it. Now let us see what are the rules. So Karibusana Raymond Cosmos, yes, the rules to be followed by the court in private international law. What rules should be followed in the private international law? So here, private international law, or we can say the other name is the conflict of laws, is the branch of law, private in some states, public in others, regulating all lawsuits involving a foreign law element where the difference is in result will occur depending on which law are applied as a lex causa. So which law is applied for the lex causa, it will depend upon it whether the lex fori will be followed over there or lex loci would be followed over there, or we have to make the foreign judgment should be followed to justify the parties. So, but here they can say that generally the private international law is it is a civil wrongs only, not for the criminal wrongs. Hence, we can say it is a private law. But it is came out of the public international law because public international law is a specie and genus, and the private international law, humanitarian law, and these are all comes under the species. And firstly, here the cursor which I have shown over here. Yes, firstly, Raymond, could you read it, which I highlighted here? Yes, I could not see your microphone. Raymond Cosmos, could you read what I highlighted there?
Firstly, it is concerned Firstly, it is concerned with determining whether the proposed forum has jurisdiction to adjudicate and is the appropriate venue for dealing with the disputes. And secondly, with determining which of the competing states' law are to be applied to resolve the dispute. Thirdly, it also dealing with the enforcement of foreign judgments.
These are the three principles in the private international law. What are those three principles? Number one, jurisdiction to adjudicate. That is number one. Number two, which competitive state law should be applied? That is called lex causa. Number three, recognition and enforcement of foreign judgment. These are the three principles. And we will revolve around these three principles in the private international law. Now let us see what is the choice of law rules. Court faced with the choice of law issued have two-stage process. Number one, the court will apply the law of the forum, that is the lex fori, to all the procedural matters, including safe evidently the choice of law rules. When the lex fori would be there and there is no dispute that, and especially the procedure law is the lex fori law. But when it comes to the matter of the substantial law is concerned, at the time, it will be a conflict whether to use the law of the forums, substantial law, or where that legal right was occurred over there, that is the foreign element and the foreign country, can that substantial law can be used over there. So that would be actually the crux and where we will study it. So number 2, it counts the factors that connect or link the legal issues to the law of the potential relevant states and apply the laws that have the greatest connection. Which one is the greatest connecting factors? The law of the nationality, EG. EG means exempli gratia. It is a Latin terminology and its shortening form is EG. And here the Latin terminology, we cannot write the initials in the capital letters. So exempli gratia, so EG, for example, that is the equivalent in English. The law of nationality, within parenthesis, lex patriae, Latin terminology, or domicile, Latin terminology within parenthesis is lex domicilii, will define legal status and capacity. The law of the state in which the land is situated, lex situs within parenthesis, will be applied to determine all question of title. The law of the place where a transaction physically take place or of the occurrence that give rise to the litigation, lex loci actus, will often be the controlling law selected when the matter is substantive, but the proper law has become a more common choice. And we have in depth studied the connecting factors. For the tort, what is the connecting factor? Yes. What is the connecting factor for the torts? Oh, I don't ask it such a big, tough question. Connecting factor in torts. If you don't know, you say pass on. I will give the answer. Is it pass on? Law of tort, connecting factor. What is that? Anyone can unmute and give me the reply. Sir, matando, matatizo, sir. Okay. Lex loci delicti, where the dereliction has taken place. That is the connecting factor for the law of tort. And for the contract, lex loci actus or lex loci contractus. For the marriage, participants, for the marriage, what is the connecting factor? Sir, we don't know.
Lex loci.
Yes, lex loci.
Celebrationist.
Celebrationist. Lex loci celebrationist is for the marriage. For the movable property, lex domicili.
Lex loci situs.
No, lex loci domicili will take the movable property. For the immovable property, everybody knows.
Patria.
Lex situs. Lex situs. So these are the connecting factors generally that will use it. And for example, suppose that A, who has a French nationality and residence in Germany, corresponds with the B, who has American nationality, domicile in Arizona, It is one of the state in the USA, and residence in Australia over the internet. See how many, at least 4 to 5 countries are involved over there. They agree the joint purchase of land in Switzerland, currently owned by the sea, who is a Swiss national, but they never physically meet, executing initial contract documents by using the fax machines, followed by the postal exchange of the hard copies. A pays his share of the deposit, but before the transaction is completed, B admits that although he has the capacity to buy land under his lex domicile and the law of his residence, he is too young to own the land under the Swiss law. The rules to determine which courts would have jurisdiction and which laws would be applied in each aspect of the case are different in each state's law. So, in theory, no matter with the court in which country actually accept the case, the outcome will be the same, albeit, within parentheses, albeit that the measure of damages may differ from country to country, which is why forum shopping in such a problem. In reality, however, move to harmonize the conflictual system have not reached the point where the standardization of the outcome can be guaranteed, the status of the foreign law. So, in the problem question, there are many countries are involved over there. At that instance, only one point one should have to keep in the mind. The choice is given to the plaintiff to use as a forum, which is a convenient to him. Definitely. And when the Lex 4E is there, then the procedural laws will be followed of the Lex 4E where the case is filed. But when the matter comes to the substantial law is concerned, at that instance we will consider it is a contract. So when it is a contract, lex loci actors and lex loci contractors, the place where the contract is concluded, the place where the contract is initiated, are made. And at that instance, where the breach have occurred over there. When the breach has occurred in a different country, and that country law is a beneficial to the plaintiff, or Lex 4E is the beneficial to the plaintiff, that is only that matter should be considered. Which is beneficial to the plaintiff, that country law would be applied over there. For instance, a foreign law is a beneficial to the plaintiff, and the foreign law could be used in the Lex forum and where the case is filed. Now you may ask, sir, whether such law is not contradictory to the law where the forum, where the case is instituted or filed. The question is, if it is a contradictory, they will try to harmonize it. If it is not a contradictory, they will use as it is, because that decision or that country law could not have any impact or contradicts with the statute where the case is filed, and it is not against the public policy also, it is not against the constitution of that country also. This will be considered because of using the illogical reasoning by the judges, and they will use which will be the beneficial to the plaintiff, and that correcting factor, and that lex causa, and even the decision which is supposed to be given in the other country, as it is, the decision will be taken to adjudicate the case where the case is filed. So this is all that about explanation regarding this. Suppose that A, the example which is given over there. So in this way we can make it out how the...
Sir,
Yes.
question, sir.
Yes, please.
Sir, Okay, the question is,
Yes.
that judges uses their discretion even if on the contract between the parties has stipulated the law to be applied?
Yes, now the question comes over there. If the whether clearly mentions over there, the law applied for the dispute is so and so, at that instance, that law could be applied over there. And whether it is beneficial to the plaintiff or whether it is beneficial to the defendant doesn't matter. Because in the contract, law of the choice is given to the party. But if they deviate it, not followed particularly the law, at the time the court can interfere it. And we have studied the same in the arbitration also. Because the Dawson and the, what is that, Tanzania Electricity Board? What do you call?
UNESCO.
Nini?
UNESCO.
TANESCO. So in that case law, they agreed together that England law should be arbitration. ICC would be the deciding factor of the tribunal. The tribunal has given such a judgment at the time, and the TANESCO said, no, it is not in a favor of me, it is a favor of him. They filed a case in the High Court. But the High Court said, no, because we agreed to, when the breach of contract comes, the tribunal will decide the case. At that instance, it struck out the TANESCO plea. And the TANESCO approached the Court of Appeal, and the Court of Appeal has held the judgment of the High Court. So, when the parties agreed together, a particular law would be applied over there, number one. Number two, the case would be filed in the particular country, even though the both of the parties are not belongs to that country. Yes, in that instance also, the court will not interfere it, and as per the agreement is concerned by both the parties, and it will be holds good, and decision will be given by that agreement only. Either the court or the substantial law, the law which be applied over there would be followed. Is it clear? Is it clear?
Yes, sir.
I appreciate.
Yes, Prof.
Okay. Generally, read, anyone can unmute and read this. Generally, read this one. Anyone can unmute and read, which I highlighted on the screen.
Generally, when the court is to apply a foreign law, it must be proved by foreign law experts. It cannot merely be pleaded. As the court has no expertise in the law of foreign country, nor in how they might be applied in a foreign court. Such foreign law may be considered no more than evidence, rather than law, because of the issue of sovereignty. If the local court is actually giving extraterritorial effect to a foreign law, it is less than sovereign, and so acting in a way that it is potentially unconstitutional.
So here they made it very much clear. Generally, the court is to apply the foreign law. When a court is apply the foreign law, the court doesn't have the knowledge about the foreign law. So it must be proved by the foreign law experts. A foreign law expert should have to explain to the court, yes, it is a correct law, it is absolutely right law, and the judgment is given also in a proper manner by following the foreign law. So it cannot merely be pleaded, as the court has to expertise in the law of foreign countries, nor in the how they might be applied in a foreign courts. So whenever the Lex Forum is following the foreign law, they will take the opinion of the foreign experts. Then only they can apply the law in their own country. Such foreign law may be considered no more than evidence rather than the law because of the issue of sovereignty. Suppose that law is merely an evidence, but it is not Not the issue, because it is not a substantial way to follow it, because every country having the sovereignty. But to make a compromise, like I told you, the doctrine of, what is the doctrine? I give respect to you, your decision, and you give respect to my decision. What is the
Principle of
doctrine?
committee.
Yes, doctrine of committee can be used over there. If the local
Reciprocity.
court is actually giving extraterritorial effect to the foreign law, they are applying the foreign law by extending the extraterritorial. It is less than sovereign and so acting in a way that is potentially unconstitutional. So now, if it is potentially unconstitutional, at that instance, it will not accept it. Extraterritorial, it cannot extend it. But it will not be any contradictory to the constitution or the existing laws or the policy of the forum where the case is filed over there. At that instance, yes, foreign law can be used as it is. And we studied mostly their recognition and enforcement of the foreign judgment. So let us see the theoretical response to this issue are that each court has an inherent jurisdiction to apply the laws of another country where it is necessary to achieving the just outcome. Just outcome means it is a naturally good and it is benefit to both the parties, and it is actually a right way of dealing the case law and that a dispute. So just outcome, they will see it, and even they can extend the jurisdiction to apply the law of the foreign country. Because if you apply the law of the foreign country, there will be a quite good justice to the parties, especially the plaintiff. That is number A. Number B, that the local court creates a right in its own laws to match that available under the foreign law. This explanation is sustainable because even in states which apply the system of the binding the legal precedents, any precedents emerging from the conflict case can only apply to the future conflict cases. There will be no ratio decidendi that binds future litigation in entirely local cases. So you know the ratio decidendi and obiter dicta. Do you have an idea? Ratio decidendi and
Yes.
obiter dicta. The obiter dicta cannot be a precedent. It is done only exclusively for that case only. We cannot use it as a precedent. But ratio decidendi we can make it as a precedent. But if the society changes over there, if the environment changes over there, at that instant law also changes. And that is the reason a high court which has given the judgment of its own can overrule it. The Supreme Court which has given the judgment by its own self can overrule it. Later part. It cannot be used as a precedent at the time. So it can be changed because depending upon the situation, the society changes, the law should change according to its same pace. Pace, I said, not space. Pace, P-A-C, pace, means the momentum, proportionate, the speed. Society changes, a law also would be changed because of it. Law is to make social engineering in the society. So once the lex causa has been selected, that is which country law could be applied is selected, it will be respected except when it appears to contravene the overriding mandatory rule of lex 4e. I told you several times. Lex causa can be accepted when that will not be contradictory to the lex 4e. Lex 4e of what? Either the statutes or the policy or the constitution. Is it clear? Here, this point.
Yes.
So each judge is the guardian of his or her own principle of order public. There is no hard and fast rule Each judge of his or her own principle order public policy, and the parties cannot, by their own act, use the fundamental principle of the local municipal law, which generally underpin areas such as the labor law, insurance law, competition regulations, agency rules, embargoes, import and export regulations, and securities exchange regulations. Furthermore, the lex fori will prevail, means law of the forum will prevail in cases where an application of the lex causae otherwise result in fundamentally immoral outcome. If it is fundamentally immoral outcome lex causae, at that instance, lex fori will be applied for the entire either procedure law or substantive law, or give extraterritorial effect to confiscatory or other territorial limited laws. So, lex causae will be not contradictory to the lex fori laws and policies and constitution. Then only it can be used over there, otherwise it cannot be used. Which foreign law or even a judgment also. In some countries, there is occasional evidence of the parochialism when courts have determined that if the foreign law cannot be proved to a satisfactory standard, when you feel that foreign law is not proved to be a satisfactory standard, then local law may be applied. Local law means lex fori. Similarly, judges might assume, in default of the express evidence to the contrary, that the place where the cause of action arose would provide certain basic protections, e.g. exemplary gratia, that is, for example, that the foreign court would provide a remedy to someone who has injured due to the negligence of another. As I told you, they will see the benefit is there for the plaintiff, especially in the matter of the torts. Because some country there is a cap, in some country there is no cap. When there is no cap, compensation is more. Damages are more. And hence, they try to apply the foreign law because the damages are more to the plaintiff. If they apply the country law, the lex fori, the damages are capped, means limited and seized, and the limitation is there, which cannot give the more than that. So at that instance, we can use the foreign lex causae to give the benefit to the plaintiff. Finally, some American courts have held that local law will be applied if the injury occurred in an uncivilized place that has no law or legal system. Suppose where a tort is occurred over there, or a breach of contract is occurred over there, but there is no law at all, and there is no legal system at all, at that instance, we would follow the lex fori where the case is filed. Is it clear? Local law will be applied if the injury occurred in an uncivilized place that has no law or no legal system, where a person can file a case, lex fori, that country law would be applicable. Not the place where a contract is breached, number one, or a tort is occurred, number two, or a divorce is taken place, number three. At that instance, there is no law, and at that lex fori can be used as a law. Means local law could be used as a law. So that is given in the Walton versus Arabian American Oil Company, and this case law we dealt at least 2 or 3 times. And please check the case law. If the case has been submitted to arbitration rather than the national court, say because of your forum selection clause, an arbitrator may decide not to apply the local mandatory policies in the face of the choice of law by the parties if this would defeat their commercial objective. Suppose the commercial objective is defeated over there at the time, they will not apply the law of even forum. So they could apply the law of the lex causae at that instance, because overall that a plaintiff who comes to the court should not go with the empty hands. That is the motto of the private international law. I repeat, the plaintiff who comes to the court should not go with the empty hands. Where there is a justice to him should be given. Even they can modify the law. They take the law of the other country. They take the judgment of the other country, and they see that the justice will be, a just justice will be given to the plaintiff. However, the arbitral award may be challenged in the country where it was made or where enforcement is sought by one of the parties on the ground that the relevant order public should have been applied. That means the arbitral award is there. We discussed the same thing in the Dawson versus Tedesco. Arbitral award very clearly mentions that if the party agreed over there at the time, no court would give the judgment against what they agreed in the instrument or in the contract. If the lex loci arbitri has been ignored, but there was no real and substantial connection between the place of arbitration and the agreement made by the parties, a court in which enforcement is sought may well accept the tribunal decisions. So now the question comes over there. If there is no such an agreement between the parties, which law could be applied in case of the breach? Or which court having the jurisdiction to entertain such a case? At that instance, the lex fori will decide it, which is justice to the party, and they will follow both the procedure law, lex fori, and substantial law, lex fori. Even though the party agreed the other country law, because if you could make such a thing, it will be a objective of the commerce will be futile. It become useless. At that instance, they cannot make it out. So that is the same thing which is said over there. The substantial connection between the place of arbitration of the agreement made by the parties, a court in which enforcement is sought by well accept the tribunal decision, but the appeal is to court state where the arbitration was held. The judge cannot ignore the mandatory provision of the lex fori. One should not forget the mandatory provision of the lex fori, where the case is filed over there. So that would be the followed, because the object of the mercantile or the business will becomes sifuri, means zero. The object of the commercial business become a zero. At the time they don't follow it. They follow the lex fori only. So choice of law, because we are already read this, but it is a repetition, because at what time the court will apply what law. So it can apply at one time one connecting factor. It will apply in the same facts in another connecting factor on the theories, and then give the judgment. Because I told you, no, there is no hard and fast rule. Sema? There is no hard
There
and
is no
fast
hard and fast rule.
Complete it. Complete the sentence.
There is no hard and fast rule.
Complete the sentence.
It is the reasons of the judge to choose what law to be applied.
Yes. And to give the justice to the parties, the judge will use the reasoning and decide the case. So one case, he follows the one rule. In another case, he follows the different rule for the same set of the facts. So that is the thing. And we know you already studied the choice of law. Number one, jurisdiction. Number two, whether it is a contract, whether it is a tort, whether it is a property law, and how it can be. And that comes in the characterization, and later on it will decide it whether the substantial law would be followed or lex fori law would be followed. Means lex loci will be followed or lex fori will be followed, will be given in the characterization. So it is nothing but the repetition we made it out. And let us see that only characterization. The court then allocates each aspect of the case as pleaded, and it is appropriate legal classification. For each such classification, its own choice of law rules, but distinguishing between the procedural and substantial rules requires a care. So when you are using the lex causae, and the lex causae, whether lex loci means where the right is existed, that country law could be used as a substantial law, or where the case is filed over there, that is the lex fori, the law of the forum. The law of the forum, it is a clear-cut idea that procedure law would be followed of the law of the forum. There is no doubt at all. Procedure law would be followed in the law of the forum. When the matter comes to the substantial law, now the question comes over there. Whether we should follow the lex forum, lex fori law, which is existence over there, that is, the substantial law, or where the right is occurred, where the right exists, means lex causae. That is called lex loci. Lex loci in the sense lex causae here. Where the right is emerged over there, the breach has occurred over there, and the tort is committed over there, and the divorce took place over there, the marriage is conducted over there, whether that country law would be followed. The court then applies the relevant choice of law rules. It should be noted that in few cases, usually involving the family law, the incidental question can arise which complicate this process. So now family law, of course not that. If the parties agrees over there, so it is a binding factor to them. For instance, I will ask one question. The two Indians, they married in India, but they are working in the different countries, say Tanzania, and both are wife and husband. Because of the various other reasons, can they take the divorce in Tanzania when they are married in India? Yes.
No,
Why?
because the place where the marriage was celebrated is not in Tanzania. It is in India. So
But
they are guided by Indians.
But they agreed. When they agreed, where is the question of not giving the Tanzania? Sir, we voluntarily accept the jurisdiction of the Tanzania. We voluntarily accept whatever the decision will be given over there, because based on the reason, and you give us the judgment. When they are going to give the judgment at the time, they will definitely ask the embassy. These people came to get the divorce. Now what should we do? So the embassy will come into the picture. They said, yes, the law which is prevailed in their country is allowed to give the judgment as a divorce. So now you can proceed it. You can give the divorce judgment. Yes, you can give it. Because they will take the opinion of the ambassadors and high commissioners. Even the people, those who wants to marry, and they are Indians, yes, they can marry in the high commissioner's office as a civil marriage, and he will conduct the marriage. When he conducts the marriage, because he knows the laws of that country, and where there is no such a hitch to marry each other, because there is no consanguinity, and there is no other, because their statuses, they are capable of doing so, they are the same, having the capacity, and it allows it there in the India. At that instance, a marriage will be conducted in the High Commissioner's office or embassy, and that marriage certificate or marriage will be stamped by the local authority, the local court. The local court will authenticate it. Yes, it is a valid marriage. So that way it can be done. But as a general rule is there, when you lock with a key, the same key should have to unlock it. It is a general rule. Means where the marriage has taken place, there only you are supposed to take the divorce, not in other place. But they cannot go to their country because they don't want to go to their country. They want to take the divorce here. At that time, it can be done. But the interference of the embassy is there because the embassy will give what is the legal position, whether it can be divorce should be given or not. If it is given, how much time it will be taken? Because divorce will not be given because they give the certain chance that for the reconciliation. So it will not be make effective immediately. At least they should wait for to minorities. It is 18 months. Now they reduced to 1 year. But somebody challenged it. Why we should have to wait for the 1 year? We should be given the spot. But they said at least for the 6 months because the mind will be changed. So a duration would be there that reconciliation possibility is there. Why should you have to take the divorce again? Because if you get the divorce again, Matumba husband will get it, and the woman, the man will think that if I could get the divorce and if I want to marry again, Matumba, the second hand wife will come to it because he never expected the first hand wife. The reason is a white cloth, when it's torn over there, it will be patched by the white cloth only, but not the black cloth. So when you are second hand, you will get the second hand wife. When you are the first hand, you will get the first hand wife. The same applicable to the man also. So now these are the choices of the stages. We read it, and but still I have posted this one to you to your email. I don't know whether you have seen it or not because there is more status. Yes, status is there, relevant for a wide array of the issues. Self-evidently, unless the proposed litigant has a legal personality, there will be no jurisdiction. It will also be relevant to my immigration, entitlement to the social security and similar benefits, family law, contract, etc. So the choice of law is the law of domicile, that is the lex domicile, if the forum is a common law, or if it is a civil law, then it is a nationality, that is the lex patria, or the habitual residence if the forum is a civil law, applies to determine all questions of status and its legal attributes. So if it is the common law country, we can say the lex domicile. If it is a civil law country, we will use the, what is the connecting factor? Participants, give me the answer.
Nationality.
It is the lex patriae, nationality. The lex for it determines the domicile and the nationality or the habitual residence and applies the law to establish an in rem sect of the rights and capacities. Thus, under the same laws, the status of illegitimate affect the right of the inheritance in the case of an intestacy, etc. As to corporation, the choice of law is the law of the incorporation, that the lex incorporation is where it is registered for all matters of capacity. Suppose if the child is a illegitimate child, what is the domicile of the child? Yes. What is the domicile of the child? If the child
With
is
the mother.
Sema. Anyone can unmute and give me the answer.
Domicile of the mother.
If the child is a illegitimate child, then what is the domicile of the child?
Of the mother.
Of the mother. If the child is adopted by the parents, what would be the domicile of the child?
Of the adopted parents.
Adopted parents, especially father. Because our country follow the patriarchal system phenomena. That is a paternal phenomena, not the maternal phenomena. Is it clear? Say yes.
Yes, please.
Yes.
And we dealt with domicile very lengthy manner. So just to go through some of the points over here, domicile. And the lessee contractors, we already dealt in the connecting factor. The law of the place where the contract is made, and the law of the place where the contract is acted, actus. So there is a light difference where the contract is made and where the contract is implemented, actus, acting. So there is the thing where the contract is made, naturally it is not the point to be considered. Where the contract is executed, there it will be considered more. The more significant relation. Suppose the two Tanzanians went for a fair, industrial fair to the Dubai, and they made the contract over there. Does it mean that Dubai contract law should be applied? Yes. Two Tanzanians went for the industrial trade to Dubai, and they made an agreement over there. At that instance, do you mean that the contract law of the Dubai should be applied? Answer no. The law where they hails from, it could be applied. Domicile, that would be applied. So that we study the law of lex contractors and it is a repetition, but certain points are very much important. See, this bullet is, let us see, whether the forum court has a jurisdiction to hear the case. See the problem, forum shopping. Because court will give the discretion to the plaintiff to file a case where it is convenient to him or her. Number two, it must then characterize the issue, that is ideste, means that is allocate the factual basis.